Crime in Court. My name is Heather, and this is an update in the Delphi case. So we are talking about Indiana versus Richard Allen, and this is the case. The subjects of this trial are Abby Williams and Liberty German. They are the victims in this case, and we want justice for them. And justice for them is the correct person going or persons going to prison for this crime, the horrific crime of what took place in 2017. And I personally don't believe that Rick is their guy, just based off of the extremely weak case they have and the way that they are so adamantly trying to hide everything. In the state, the prosecution and Judge Gull have been basically covering up for the real perpetrators in this case, in these crimes. So let's get into it. We have a lot to get through. There's been several documents dropped all within the most recent few days, and I'm just getting to them now. So I apologize for any delays. We are kind of doing some remodeling around the house. It's been kind of noisy, so hard to record. So get some quiet now. Let's get into it. So the title of this thumbnail or this video is "The State Objects. What is Nick trying so desperately to hide?" And while we have many documents, we're not just going to be reading documents from the state, but we are going to read several of the documents that are from the state and what they're trying to say. So we're covering a lot of topics tonight, not just Nick is what I'm trying to say, but we're going to start out with Nick. All right. So Nick, Slick Nick, as we like to call him, is Nick McLeland, who is the one pictured with his mouth open there in the gray suit. And obviously, Richard Allen is the other individual pictured. And I've got someone there crossing his hands and while taking an oath because what is Nick trying to hide so much? If they had a solid case against Richard Allen, Slick Nick wouldn't have to be so slick. So let's get to this first motion, which is the state's objection to the defendant's motion to jury for the jury to view the scene. So in the last video, or one of the most recent videos, we talked about the defense wanting to view the jury scene, not just the crime scene, but different parts around the Monon High Bridge, the Freedom Bridge, right? I think that's the name of the other bridge that's there, and areas around the crime scene, not just the crime scene. So they asked for several spots yeah, Freedom Bridge. They asked for several spots, and this is the state's response as to, and Nick, Gull said that she was taking it under advisement until she heard from the state. And you knew the state was going to object. So she was just waiting for the state to object to this jury view before she denied it. That's my opinion. Come at me. I don't care. All right. So now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland and respectfully objects to the court ordering the jury to be transported to the Freedom Bridge, the Monon High Bridge, to the site where the bodies of the victims were located, and to the site of the old CPS building to view those areas. The state would, as the court, ask the court to consider the following. Number one, that the defense filed a motion to have the jury view the scene on September 23rd, 2024. That the state objects to the jury going out to view. Hold on one second. Sorry, I feel like you guys can't hear me when my dog's toes are tapping on the hardwood. So, number one again, that was the defense filed a motion to have the jury view the scene on September 23rd. Number two, that the state objects to the jury going out to view those areas requested by the defense for the following reasons. A, the terrain where the bodies were found is very difficult to traverse and would be dangerous for the jury to get to. I'm just going to stop there and go, that's the exact reason why, not that it's dangerous, it's not dangerous, but they're calling it dangerous, but they need to know. the geography of the location to realize that from where they were to where they were found, it's difficult to get to. They need to see it for themselves. They need to see the layout. But he's arguing the very reason that they shouldn't is because the terrain is difficult to traverse. Well, that's part of the reason why it strains credulity. Blah, it strains credulity to believe that only one person got them over there and was able to do this crime. It really does not seem likely that it was done by one person. We know that the cops even said that they thought it was multiple people involved in the beginning. And even when Rick Allen was arrested, they announced that they were leaving the investigation open in case there were other people. So it's just very odd. And I believe it's very important that the jury know the terrain. So his argument right there, I think, is stupid, but Judge Gull is going to be like, yeah, yeah, that's right. That's good. B, traveling to where the bodies were found and to the opposite end of the Monon High Bridge would involve encroaching on two private landowners' properties. So what? You're the government. You can do that. You can do it was a crime scene. Um, get permission from the landowner. It's not that difficult. All right, C, that it would require a substantial amount of time and resources to take the jury to those areas while ensuring that they are sequestered from the public and outside influences. No, no, it wouldn't. How do you do any jury scene? You have to do it the same way. It's not that difficult. It's not going to take that much time or resources. D, that the areas of where the bodies were found along with the site of the old CPS building are substantially different from the time the crimes occurred. Okay, well, then explain that in your arguments, your opening and your closing statements. Don't just because the area has changed doesn't mean that that's not a good enough reason to not take them there. 3, that the state intends to introduce into evidence demonstrative exhibits, maps of the various areas, and drone footage of the various areas to show the jurors the various places outlined in the defense's various request. I just had to put that in there because how many times can you say various in one sentence? Number 4, that any benefits of the jury visiting those areas is outweighed by the damages such a trip presents to the jury and to the fairness of the trial. What? So the jury's not going to benefit from going and seeing it themselves because it's so dangerous, so you say. And that's giving them a fair trial? I mean, who deserves the fair trial here? It's Rick Allen. Rick Allen gets the fair trial. He's the one that is entitled to it, not the jury, not the state. It's Rick Allen. It's his rights that the defense is fighting for. Anyways, number 5, that the state does not believe it is proper to have the jury view the scene or the other various areas because it's not proper according to the state's thinking. That's not an argument. That's not a legal argument. Wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and files their objection to the defense's motion for jury to view scene and would ask the court to deny the same. And I would put money on the fact that she will deny it almost instantaneously. If she hasn't already, I haven't seen it come through. And that was filed when 9/27. So, okay, it wasn't instant. But I have a feeling we'll get an answer soon from Judge Gull. All right, next filing is this. It just says state's response. State's response to what? He doesn't say. All right, so now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully submits its response to the defendant's motion to compel deponents to answer questions and in support of said motion would state the following. All right, now we know what they're asking for. So those questions that we had from the defense, there was a list of questions, which is kind of intriguing, the different questions that were the state told them not to answer during these depositions. So people like Jerry Holman and some of the investigators were told not to answer certain things that were being asked at a deposition. The state doesn't represent those people. The state represents the state. So why the state was objecting and saying don't answer that to those individuals just boggles my mind because he's not their lawyer, number one. Number two, in a deposition, it's very rare for anyone to say, don't answer that, you can't answer that. In those cases, the attorney that's asking the questions will say, okay, I certify those questions. So they did certify the questions so that they could come back and say, we want these answers. Well, now the state is coming back and saying, well, here's why you shouldn't answer those questions. This is why. Okay, so number one, that the state believes the information that the defense is asking the court to compel is privileged information as it is work product or pertains to communication between the state and one of their witnesses, or it is not relevant to the guilt or innocence of Richard Allen. That is not up to the state to decide. The state doesn't get to the state does not get to decide relevance as to Richard Allen's guilt or innocence. That's up to the jury. That's up to the jury to decide if conversations between these law enforcement officers and witnesses or the prosecution, if those are happening and it's not your work product, then it's probably discoverable and probably relevant. Number two, that as to the August 10th, 2023 deposition of Jerry Holman, substance of conversations had between Sheriff Tony Liggett and Jerry Holman while the prosecutor is present to discuss trial strategy is work product and therefore confidential. How can a conversation with law enforcement and the prosecutor be work product? That doesn't make any sense unless law enforcement is working for the prosecution. Are they? Like, what is going on here in all of these? It's not just Delphi, it's not just Canton, it's everywhere that these things are happening and we're just waking up to it. Guarantee it. Number three, that as to May 3rd, 2024, deposition of Jerry Holman, the decision of when to hire a blood spatter expert for trial is at the discretion of the prosecutor, and not only is Jerry Holman not in position to answer that, but the state's strategy as to when to hire a blood spatter expert is work product and is confidential. Or, okay, but why are you hiding it? Like, why does it matter so much? Was it Jerry Holman and you working together to come up with when you hired as blood spatter expert, and in that case, it's work product? How are you in he's basically saying they're in collusion. They're colluding together because it's the prosecutor who gets to decide, not Jerry Holman. And why is there conversation about it work product? Because he's working with the law enforcement officers that tried to put him away or frame him. I don't know. Put an innocent man in prison potentially. Number four, that as to the March 22nd, 2024 deposition of John Gallipo, who's the warden of the first place where he was housed, conversations between Mr. Gallipo and the attorneys for the Department of Corrections are confidential as attorney-client communications. Why? That doesn't make any sense. Attorney-client, the Department of Corrections and the warden, that's confidential attorney-client privileges? No. Where's the attorney? It's the Department of Corrections because they talked to the attorney for Department of Corrections, so it's an attorney-client communication, therefore they shouldn't know anything about it. That's bull. Um, All right, number 5. That as to the April 18th, 2024 deposition of Joshua Robinson, he was an officer involved in the investigation. Conversations between Mr. Robinson and his attorney are confidential as attorney-client communications. Number 6, that as to May 3rd, 2024 deposition of Tony Liggett, the purpose of the Unified Command meeting is not only not relevant to the guilt or innocence of Richard Allen, but as also confidential as the prosecutor was involved in the conversations, which included work product. Again, you're working with law enforcement. You're saying right there, you and law enforcement are somehow colluding together. That's what I'm taking out of this. The purpose of Unified Command's meeting is not relevant. Unified Command is investigating this case. How is that not relevant? And number 7, finally, that as to the September 13th, 2024 deposition of Stephen Mullen, Mr. Mullen answered the questions that the defense posed to the best of his ability. Simply because he did not answer them the way the defense wanted is not a valid reason for the court intervention. Um, I don't think that's what they were getting at, but okay. And wherefore the state would ask the court not to compel the witnesses to answer the questions, requested questions, and for all other relief that is just and proper in the premises. So, because Nick opposes these questions being answered, she's going to deny the motion. That's my take on that. All right, so state's motion in limine regarding the defense witnesses. So there is a defense witness now that the state has a problem with. Comes now the state of Indiana by prosecutor Nicholas M. McClelland for the 75th Judicial Circuit and respectfully request that the court enter an order prohibiting the testimony by Mr. William Tobin, a listed defense witness regarding firearm examination in general or the firearm examination specifically in this case until a hearing may be held outside the presence of the jury to determine the relevance of Mr. Tobin's testimony. In support of its motion, the state would show the court the following. Number 1, that William A. Tobin is listed as a defense witness and was deposed by the state on September 20th of this year. Mr. Tobin has testified that he is a forensic metallurgist and a material scientist. He has a Bachelor of Science degree in metallurgy and a Master of Arts degree in special studies, which he testified was primarily the study of law. 2, in his deposition, Mr. Tobin testified that when he has been recognized as an expert in court, it has always been as a forensic metallurgist or a material scientist. Number 3, Mr. Tobin stated that he has not examined the evidence in this case, though he testified he has reviewed some of the reports and notes of the state's firearms examiner, Ms. Melissa Oberg. Mr. Tobin testified that though he has not reviewed all of Ms. Oberg's materials, he has what he typically needs to be able to opine on the methodology that's used. So even though he doesn't have the exact materials, he has enough information to make a educated determination. Tobin went on to explain that the state's firearm expert witnesses' conclusions are based on a flawed methodology. Oh, wait a minute. So the state's witness, this expert is saying that the state's witness used flawed methods. Okay. So the defense's expert is saying that there's a problem with the state's expert, and therefore we don't feel like the defense expert is actually an expert, so we're going to question his expertise because he's questioning our expert. Does that make sense? Every side gets an expert. Like both sides get to call in their own experts. So just because they disagree is not a reason for him to nix the expert altogether. Number 4, according to Mr. Tobin, this flawed methodology is the AFTE, or the Association of Firearm and Toolmark Examiners, theory of identification, and this theory is what almost all firearm examiners follow, whether or not they are members of AFTE. So that is, he's saying, Mr. Tobin is saying that's the standard, or that is the flawed method to be used, that's used. That Ms. Olberg, at the time of her examination, was a forensic examiner with the Indiana State Police, and she, along with all other Indiana State Police firearm examiners, follow and apply the AFTE theory of identification. Mr. Tobin is not an expert in the field of firearms examination. Unlike another listed defense witness, Dr. Eric Warren. Dr. Warren, like the state's expert witness, Ms. Olberg, is not a member of the AFTE. So, okay, neither of our firearms experts on either side are a member of AFTE, but Dr. Warren holds or has held leadership positions within AFTE. Mr. Tobin's expected testimony will be that all firearms examiners, including Ms. Oberg and Dr. Warren, follow a flawed methodology and their opinions are not scientifically reliable. 7. However, the state believes that Mr. Tobin, who is not an expert in the field of firearms examination, lacks the qualifications to testify regarding the firearms examination in the case, and that his knowledge is not such that it would help the tier of fact, or the trier, sorry, the trier, help the trier of fact to understand the evidence or to determine a fact in issue in this case. So he's saying it's not going to help the jury if he testifies. A metal expert who's probably going to testify to the firearm, the casing that was left, the unspent casing or unspent round, whatever it's called. All right, so 8. Further, the state believes that Mr. Tobin's testimony would lack relevance under Indiana Rule of Evidence 401 since he is not an expert in the field of firearms examination. Finally, that the probative value of Mr. Tobin's testimony would be substantially outweighed by a danger of confusing the issues and misleading the jury. 9. The state believes that the question of whether or not Mr. Tobin should be permitted to testify in this case is very similar to a recent case out of Marion County, state of Indiana versus Caden Smith. In the Smith case, Judge Harrison ruled that Mr. Tobin would not be permitted to testify, and in her order dated January 29th, 2024, said the witness, Mr. Tobin, was being called by the defense to testify only as to the shortcomings of firearms examination in general. So, because this guy is refuting firearms examination, because it is basically junk science in a lot of people's opinions, um, because he's refuting states' witnesses, they just want him out. Because he is going to say this is not scientific evidence. Wow. The witness has not tested or reviewed any of the evidence in this case. In this cause, the defendant will have the opportunity to cross-examine the state's witness to present his defense as the shortcomings of firearms examination. The court now grants the state's motion in limine. So that was for a different case, obviously, back in this January case where some judge had ordered in the Smith case, the judge ordered that Mr. Tobin would not be testifying as a witness. However, they have to, I mean, they have to compare. It might be like an apples to oranges situation as to why he was excluded as an expert in this case. He might have been, not talking about whatever the topic was that they wanted him to. There's a number of reasons why the judge might have done it, and every case is different. And he's probably been approved as an expert many times in court, so just this one time doesn't mean anything. All right, so wherefore the state of Indiana, by prosecuting attorney Nicholas C. McClelland, respectfully requests this court to be granting the following relief. A. Order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside the presence and hearing of the jury. And B. to further order said persons to make no reference to the fact that this motion has been filed and granted and all other relief just and proper. So don't mention to the jury that you can't mention your witness, basically. And don't mention anything about this witness or anything he's going to say to the jury until you have permission from Judge Gull. So we know how that's going to go over. Because this guy refutes ballistics as real science to prove anything, to put anybody away, uh, this is going to be the reason why they don't want him called. It's just ridiculous. All right, so I think that was it for the state. So what do you think? Those were the state's motions. What do you guys think of all these motions? Don't answer questions. Don't bring in your witness on ballistics and metallurgy. And don't let the jury view the scene. What are you hiding so much from, Nick? If your case was rock solid, you wouldn't care. You wouldn't care if the jury saw viewed the scene. You wouldn't care if those law enforcement officers answered specific questions about the investigation and other people that they investigated. It wouldn't matter to you because your case would be so rock solid that Rick Allen was your guy. But because it's not, here we are trying to prevent the defense from defending themselves. You've cut them off at the knees by not allowing any of the Odinist talk or the other suspect talk. Now you're not even letting in one of their witnesses, which the whole case as to why you pinned Rick there was because of this unspent bullet casing or this unspent round that apparently you can do some kind of, apparently the state believes that you can do some kind of ballistics on an unspent round and it be accurate. Makes no sense to me. But okay. So explain, like if I'm a juror, I want that explained to me. How did you do any kind of testing on an unspent round? It didn't cycle through the gun. So how? I don't get it. So that's kind of where I'm at on that. And these other questions that they can't answer just ridiculous. Again, in my opinion, they should have been answering them on the spot in the deposition. So obviously, the state's trying to hide things. And now this is a motion. We're going to move on to this next motion from a non-party, which means they're not a party in this case. So the parties in this case are the state of Indiana versus Richard Allen. So this is a non-party, the Indiana Department of Corrections, responding to the defendant's motion to compel deponents to answer certified questions. Again, what are you trying to hide? The Indiana Department of Correction, a non-party by counsel, responds to defendant's motion to compel answers to certified questions and states. Procedural background. Number one, on September 23rd, 2024, Richard Allen filed his motion to compel deponents, including John Gallipo and Correctional Sergeant Joshua Robinson. Oh, sorry, he's a correctional sergeant. I said he was investigating the case. He's a CO. So Richard Allen filed his motion to these deponents. Number two, Mr. Allen did not serve his motion on the Department of Corrections. Number three, the Department of Correction objects to the motion with respect to the certified questions directed to John Gallipo contained in paragraphs 6B and 6C and 6D of the motion because those questions call for information protected by attorney-client privilege. Hold on one second. I want to go and find the questions if I still have them. Hold on. Okay, here is 6. What did they say? B, C, and D. So here are the questions that are directed to John Gallipo, warden of Westville Correctional Facility, which is where Richard Allen was staying. And he was staying in solitary and being treated very poorly there. So these are the questions. And so, what were you asked to do when you got the document? This was an affidavit signed by John Gallipo. C, did you give any reasons why the defense could not go see where Richard Allen was living? Oh, why is that? That's not attorney-client privilege. And do you know why they made the decision for a no phone policy in Westville Correctional Facility? So they weren't letting him speak. Oh no, is it the phone not letting I think it's the issue with not letting the defense team, the attorneys, have their phones when they went into the Westville Correctional Facility because for months they were able to, and then all of a sudden it stopped. And that's when the Franks memo came out and the whole thing about the Odin patches came out. They were no longer able to have their phones with them when they went to go see Richard Allen. So they're asking, do you know why that decision was made? Did they give you reasons why it was made? And what were you asked to do when you got the document, whatever document they're talking about there? So, yeah, that's what those questions were that they're saying the department objects with those questions. They don't want to make him answer that because it's attorney-client privilege. The Department of Correction takes no position on the question contained in paragraph 6E or 6A, sorry, which was, I'm assuming some of that talking to the prosecutor was just talking about the pleadings I had filed or Andy filed, things like that. Dog's walking, sorry, hold on. So I'm assuming some of that talking to the prosecutor was just talking about the pleadings. So the Department of Correction has no objection about the whole prosecutor talking to the prosecutor part, but Nick McLeland doesn't want the defense to know about the whole conversation with the prosecutor. So isn't that telling? But Department of Corrections like, yeah, we don't care about answering that. We'll tell you. All right, number four, the Department of Correction objects to the motion with respect to the certified questions directed to Correctional Sergeant Robinson contained in paragraph 7A, B, and C, which is generally describe to me what kind of questions these were. Questions for the affidavit prepared by Elise Gallagher. So I believe that is their attorney for the Department of Corrections. B, I'm not asking you about what Ms. Gallagher talked to you about. I'm asking you what questions you answered. And C, what were those questions for the affidavit? And they're got really blurry and small. And so they're saying we don't want to answer that because those questions call for information protected by attorney-client privilege. Again, I don't see why, but okay. Department of Correction personnel. Number five, John Gallipo is the former warden of Westville Correctional Facility. He signed an affidavit in his then capacity as acting warden. That affidavit appears in the court record on October 10th of 2023 as an exhibit to the state's response to defendant's verified motion for immediate transfer for custody. 6. Mr. Gallipo was deposed by defense on March 22nd, 2024 and questioned about his affidavit. The Department of Correction was present by counsel at the deposition. I think they mean was accompanied by counsel. Number 7, Joshua Robinson is a correctional sergeant at Westville Correctional Facility. Correctional Sergeant Robinson signed an affidavit in his capacity as correctional sergeant. The affidavit appears in the court record on October 10th, 2023 as an exhibit to the state's response to defendant's verified motion for immediate transfer of custody. Number 8, Correctional Sergeant Robinson was deposed by defense on April 18th and questioned about his affidavit. The Department of Correction was present by counsel at the deposition. Number 9, Elise Gallagher holds the title of Deputy General Counsel for the Indiana Department of Corrections and is an attorney licensed to practice law in the state of Indiana. Deputy General Counsel Gallagher provides confidential legal advice to the Department of Corrections. Okay, but shouldn't we know why all of a sudden policy standards are not being adhered to? That's what they don't want us to know. Let's move on. Number 10, attorney-client privilege. In general, communications between an attorney and a client on a legal matter within the scope of the profession should be strictly confidential. 11, attorney-client privilege applies to all communications between the client and the attorney for the purpose of obtaining professional legal advice or aid regarding the client's rights and liabilities. Number 12, the person claiming attorney-client privilege must show that the consultation was a professional one and that 1, an attorney-client relationship existed, and 2, a confidential communication was involved. 13, Deputy General Counsel Gallagher was consulted in her professional capacity and provided confidential legal consultation for her client, the Indiana Department of Correction, by communicating with Mr. Gallipo concerning his affidavit which pertained to his professional role with the Department of Corrections. I don't know if you can just use this as your shield to hide behind and do illegal, nefarious things. I don't think having those conversations with an attorney first is going to help your case, but whatever. 14, Deputy General Counsel Gallagher was consulted in her professional her professional capacity and provided confidential legal consultation for her client, the Indiana Department of Correction, by communicating with Correctional Sergeant Robinson concerning his affidavit, which pertained to his professional role with the Department of Correction. Number 15, privileged communications are outside the scope of discovery and are objectionable at a deposition. Does this make Gallagher potentially a witness? I don't know. If you can't get the information in one way, you got to be able to get it in another way. And that attorney might be able to answer some questions that the individual can't or isn't allowed to. All right, application to Mr. Gallipo. 16. The answer to the question identified in paragraph 6B of Mr. Allen's motion is protected by attorney-client privilege. What was 6B again? That was shrink you down a little bit. 6B was. And so, what were you asked to do when you got the document? That's the question. Why is this? This is very blurry. Sorry. So, what were you asked to do when you got the document? Is what the question was. There we go. Oh, it's right there. And so, you were asked. And what were you asked to do when you got the document? B. Basis of privilege. Mr. Gallipo's testimony was that he believed the affidavit to have been prepared by the legal team at the Indiana Department of Correction and that he had an in-person meeting with someone on the legal team. So is it even accurate if somebody else wrote it for him? The question calls for a response of what Mr. Gallipo was instructed to do by a DOC attorney at the meeting. Maybe that one, maybe. There's argument possibly for that one, but for all the rest, I think they need to answer these. Number 17, the answer to the question identified in paragraph 6C of Mr. Allen's motion is protected by attorney-client privilege. A question, did they give you any reasons why the defense could not go see where Richard Allen was living? They wanted to see his cell and his, the conditions of where he was. B. Basis of privilege. Mr. Gallipo testimony was that the decision in question was made by the legal team at the Indiana Department of Correction. The question probes the legal justification provided by the legal department. Well, this is something they might have to answer to in the court of law, especially if if it goes to a conviction, which I'm 99% sure that it's going to, only because it's crooked and corrupt there, and they're trying so hard to to um, eliminate the truth from coming out or to prevent it anyways. Yeah, so I believe there's going to be a conviction and all of this is going to be appealed. Every single thing that the state is doing. There are so many reasons to appeal. Moreover, in order to compel an answer to the question identified in paragraph 6C of Mr. Allen's motion is unwarranted because notwithstanding the objection, Mr. Gallipo answered the question. Number 19, the answer to the question identified in paragraph 6D of Mr. Allen's motion is protected by attorney-client privilege. A question, do you know why they made the decision for a no-phone policy at the Westville Correctional Facility? Basis of privilege, Mr. Gallipo's testimony was that he believed the policy decision to have been made by the Department of Corrections legal team. So you're just hiding behind the legal team. It's all legal. Everything that we don't want to tell you is it was communicated to us from the legal team and we can't tell you. Privileged. The question calls for Mr. Gallipo to divulge the legal team's rationale. Application to Correctional Sergeant Robinson 20. The answers to the questions identified in paragraph 7A, B, and C of Mr. Allen's motion are protected by attorney-client privilege. Questions generally describe to me what kind of questions these were about the affidavit. I'm not asking you about what Miss Gallagher told you or talked to you about, but I'm asking you what the questions were you answered and what were those questions for the affidavit. Correctional Sergeant Robinson's testimony is that he spoke with Deputy General Counsel Gallagher about the affidavit. The questions directly seek communications between Deputy General Counsel Gallagher and Correctional Sergeant Robinson for the purposes of preparing the affidavit, namely what questions Deputy General Counsel Gallagher asked or provided to Correctional Sergeant Robinson to assist in preparation of the affidavit. Conclusion, for the reasons stated herein, the court should deny the motion to compel as to the questions they've already talked about, and that is signed by a Theodore Rakita, the Attorney General of Indiana, and an Aaron M. Ridlin, the Deputy Attorney General. So that is that. Moving on to the next filing. News Media Coalition's motion to inspect public trial exhibits. The News Media Coalition, which refers to the following entities collectively: Indiana Broadcasters Association, Hoosier State Press, the Associated Press, Circle City Broadcasting, Scripps Company, that's Core TV, I believe, Nexstar Media, Newhoff, Wolf Boom Radio, Gannett Satellite Information, the Indianapolis Star, and the American Broadcasting Companies, ABC News. So that is everyone in this coalition together. Respectfully moves the court to allow inspection of the state's and defendants' exhibits submitted into the public record during the pretrial hearings in this matter conducted on July 3rd and through August 1st. It really was, or July 30th through the 1st of August. The News Media Coalition also respectfully requests that the court allow inspection of the state's and defendants' exhibits submitted into the public record during the trial scheduled to begin on October 14th. We're going to trial October 14th. And for other hearings that may occur in this matter in support, the News Media Coalition states the following. Factual background. Number 1. On August 26, 2024, WTHR, a member of the News Media Coalition, requested via email that the court allow inspection of the exhibits submitted by the parties during the pretrial hearings on July 30th and August 1st. Pursuant to Indiana's Access to Court Records rules, the other members of the News Media Coalition support the request. Number 2, the request acknowledged that some of the exhibits were submitted under seal without any required written notices, and clarified that only the exhibits already submitted into the public record were part of the request. Number 3, the request stated WTHR's preference for inspecting the records electronically, but acknowledging the court's busy schedule, also suggested physical inspection at the Allen County Courthouse as an alternative. So, even if you can't get them to me, I'll come to you, Judge. Number 4, on August 30th, 2024, the court responded to the request by stating the exhibits that are not confidential or subject to non-disclosure will be available after the conclusion of the jury trial currently scheduled October 14th through November 15th. If there is a conviction, the availability would be delayed until after the sentencing hearing. Any inspection would occur in the Allen County Courthouse. So why do we have to wait until the jury trial concludes to and the sentencing? Why do we have to wait until then to see these public documents? They're public records. They should be public. That's the whole point. Number 5, the trial exhibits already submitted into the public record indisputably are accessible to the public per ACR Rule 4. Number 6, on information and belief, the News Media Coalition understands that the court is working to grant access to the requested public exhibits, but the public currently lacks any visibility into the process. B, access delayed is access denied. 7, in seeking public access, the media acts as surrogates for the public and plays a vital role in criminal matters. And that's according to this Richmond versus Virginia. 8. Consistent with these principles, the General Assembly expressly recognizes Indiana's public policy that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and employees. Number 9, apart from well-reasoned policy considerations, the public interest in accessing judicial records has constitutional dimensions. The News Media Coalition, as members and representatives of the public, are presumptively entitled to judicial documents and proceedings under the First and 14th Amendments to the United States Constitution. So hand them over, Judge Gull. Number 10, denying the News Media Coalition and by extension the public access to exhibits already entered into the public record for 3 months or longer violates the United States Constitution and common law public access rights. And I would also include her not letting us, not letting media in. And she's severely curtailing media and she's not letting anything be streamed. So I think that also violates public access rights to a free and open trial. 11. The loss of First Amendment rights for even minimal periods of time unquestionably constitutes irreparable injury. 12. The public's interest in the public trial exhibits is especially acute in this high-profile criminal case that has garnered substantial public attention in the local community and beyond, and where the court, in its discretion, previously has denied requests for recordings of court proceedings and for cameras in the courtroom. Wherefore, the News Media Coalition by counsel respectfully requests that the court allow inspection of the state's and defendants' exhibits submitted into the public record during the pretrial hearings in this matter conducted on July 30th and August 1st, that the court allow inspection of the state's and defendants' exhibits submitted into the public record during the trial scheduled to begin on October 15th and for other hearings that may occur in this matter and for all other just and appropriate relief. And that is coming from a Margaret Christensen from a Denton's Brigham Greenbaum LLP. So that's the law firm that she works with. And so, yeah, that was sent on September 30th to Carroll County. This is just the trial exhibit or the exhibit for that hearing. This was, talking about these are the things, under the rule. I'm requesting to inspect these exhibits, and Judge Gull's response was non-disclosure will be available after conclusion, or they're subject to non-disclosure, and will be available after the conclusion of jury trial. Why do we have to wait till then? That's ridiculous. Here is the courthouse management and decorum order. Moving on to the next. I told you guys we had a lot to go over tonight. So, this case has generated substantial public interest and media attention. In light of this interest, the court has set forth rules of conduct and guidelines designed to govern the expectations of the people involved in the trial and those observing the trial, so that the decorum of an open court will be maintained throughout the proceedings. The purpose of this order is to secure the defendant's constitutional rights, yeah, right, to a fair and impartial jury while permitting the public and press to exercise their First Amendment rights. In addition, the order protects the identity of jurors. Pursuant to the court's inherent authority to assure the proper administration of justice, it is therefore ordered that the following rules are in effect. The court may rescind or modify the order at any time. Any person or organization who violates this order will be subject to the discipline of the court, meaning Judge Gull will punish you, including contempt and permanent exclusion from the courtroom. Here is the schedule. Schedules are tentative and can be modified daily. The judge invites media representatives to meet with her and counsel of record on October 17th at 3 p.m. in the Carroll Circuit Court at the Carroll County Courthouse to discuss this order. At the conclusion of the meeting, video and/or still photographs of the interior of the courtroom may be obtained for media use as B-roll or stock photos. So she's giving them the opportunity to create stock photos of the courtroom when it's empty, but not when court's in session. All right, so jury selection is scheduled to begin October 14th and will last through October 16th. How do they know they're going to get a jury in 2 days? It could take longer than that. The trial is scheduled to begin October 17th and last through November 15th. All sessions are scheduled to begin at 9 a.m. and conclude at approximately 6 p.m. There will be a recess for lunch and brief recesses in the morning and afternoon. Security during these proceedings shall be provided by the Carroll County Sheriff's Department. All persons entering the Carroll County Courthouse shall be subject to standard security protocols. The Sheriff of Allen County Civil Division officers will provide security in the court and attend to the jury. So Allen County is in charge of the jury. Upon entering the courthouse, all media representatives shall identify themselves and produce appropriate identification, photo preferred. Additionally, they may not possess any electronic devices, including any audio or video recording device, camera, cell phone, or tablet. So they're going in there with a notepad and a pen, and that's it. Media credentials. The court appoints George I. James to administer the media credentialing process. Credentials will be issued within the court's discretion. So the court gets to decide who is the media in this case. Who's going to report the way I want it to? I'll let those guys in. All requests for credentials must be made to George I. James via this phone number by noon on October 10th. Any person requesting a media credential must be prepared to present credentials identifying the person as a member of a recognized media organization. Let me tell you, folks, you don't need that to be a member of the media. I'm a member of the media because I put out media and I try to convey newsworthy stories to you guys. So therefore, I should be able to get media recognition, media credentials. But no, you have to be a member of a recognized media organization like an ABC, a Court TV, a big name. You can't be independent. You have to be recognized. That's BS. And that makes me furious because as we know, Mass media is not covering this. Mainstream media is not covering this the way that it needs to be covered. They're not going through the court documents. They're not showing you how Richard Allen's civil rights are being taken away from him. But independent media is doing that for you guys. And that's why you're here on YouTube getting your answers, getting the answers that you want, the questions that you have, because mainstream media is not telling you like it is. But Judge Gull is going to decide who can come into her courtroom, and you better be associated with some kind of organization. You can't be independent or anything like that. Any person requesting a media credential must be presented or prepared to present credentials identifying the person as a member of a recognized media organization. Credentials shall be valid for entry to the courtroom during the trial unless they are rescinded by court order. Media should be prepared to display credentials at any time during the proceedings. Credentials will be assigned to the media organization as opposed to a specific individual in the organization. Credentials so it's for ABC News, and so let's say Jim Bob can go on Monday, and Tuesday, uh, Jane Bob can go and report on it. So anybody with that organization, I guess, can use that credential. Credentials may be obtained October 11th at 2 p.m. from George. All right. Access to the courtroom. The bailiff will allow entrance to the courtroom beginning at 8:30 a.m. Court starts at 9. Once a court session begins, distractions will not be allowed. All right. Specifically, the bailiff will only allow entrance and exit during designated breaks in the trial or when the witness is entering and exiting the witness stand. So if you got to go to the bathroom and you're in the in the galley, you can't go. Or if you do, you can't come back in. If a person chooses to leave the courtroom during a court session, he or she will not be allowed to re-enter until the next break in the proceedings. Seating. All persons must be seated during proceedings. There will be no standing except for court security and bailiff officers. No person will be admitted unless there is adequate seating. There will be designated seating areas for counsel, parties, families, and credential media. The defense will be allocated 10 seats. The prosecution will be allocated 10 seats. The families will be allocated 20 seats. The credentialed media will be allocated 12, 8 for television, 2 for radio, 2 for newspaper. That's weird how they did that. And the general public will be allocated the balance of the seats in the courtroom. If seats are in high demand, media may be limited to one representative from each news organization. During jury selection, there will be a reduced number of seats available to allow seating for all prospective jurors. The court has previously issued a separate order addressing jury selection in Allen County, Allen Courthouse. All reserved seats will be available on the first come, first served basis. Groups will be directed to their respective seating area. Unoccupied seats in the courtroom may be given to the general public if the court determines it appropriate in the court's discretion. Dispute. Any dispute among media, whether one organization or network is taking up too many seats, whether a specific individual constitutes media, whether a member of the press has correctly identified their network affiliation, will be decided by the media organizations collectively. What? That is bizarre. She's like, I don't want to deal with your disputes. Get out of my face. If the dispute cannot be resolved by the media and it results in seating issues, the court may employ a blind draw seating arrangement where all present members of the media place their name in a draw and the court seats press according to the drawn names and the number of the media seats available. So they'll just do a drawing. Jury. Completed questionnaires will be treated as confidential documents pursuant to provisions of Indiana Jury Rule 10. Personal information relating to a juror or prospective juror and not disclosed in open court will be kept confidential other than for the use of parties and counsel. No party, counsel, or court staff member shall publish or otherwise disclose in any way the name, address, or likeliness of any juror or prospective juror in a manner that discloses the identity of that person except for information which is disclosed in open court. So you can't dox them, basically. Potential and impaneled jurors will be identified only by their juror number. During the trial, media is directed that no photograph or record of the jurors is allowed, they can't even have cameras or a cell phone, including the juror entrance or exit from the courthouse if jurors are sequestered. This prohibition shall also include travel, dining, and lodging locations for the jury, as well as parking and transportation vehicles where the jurors are present. So just stay away from them, period. The media shall make no attempt to contact or question prospective or impaneled jurors until the court has discharged the juror. Each excused juror will be provided file-stamped, dismissed, excused paperwork clearly indicating that he or she is no longer a juror. To ensure prospective and impaneled jurors do not overhear media interviews, press interview locations will be restricted. At the end of the trial, the court will ask jurors if they are interested in speaking with the press. The court will facilitate a location inside the courthouse where press will be permitted to interview jurors, if any, who wish to comment at the end of the trial. Photography and video in the courtroom prohibited. No still or video photography or audio recording shall be permitted in the Carroll Circuit courtroom or the courthouse. Again, what are you trying to hide, Judge Gull? She was a she basically spearheaded a program to get cameras in courtrooms, yet she doesn't want a camera in this courtroom. Why? It really makes you wonder. Any violation shall result in the item being confiscated and erased, and violators and their affiliated organizations are subject to being excluded from the courtroom for the remainder of the trial. Any interception, transmission, reproduction, rebroadcast, or dissemination of the audio signal created by the court's audio system is prohibited pursuant to the rules of the Indiana Supreme Court. The Supreme Court? Since when does the Supreme Court say you can't do something in a state court? That's weird. Or is this federal? Are we in a federal court? If it's federal, it's not federal. Federal court, you cannot videotape anything or rebroadcast anything in federal court, but this is not federal court. This is Carroll County. I'm so confused. Why is it the rule from the Supreme Court of Indiana? I think she'd lie in there. Any voice recognition software used to capture and transcribe courtroom procedure is also prohibited. Still and video photography and audio recordings are permitted only outside the courthouse. All recording equipment is permitted in this area. Media interviews outside of the courthouse building generally are not regulated by this order and are instead subject to the administration of the law under the jurisdiction of the Sheriff of Carroll County and the Delphi Police Department. The court must also guard against prospective and impaneled jurors overhearing media broadcasts and interviews. To limit the potential exposure to jurors, the court will impose some restrictions as authorized by Indiana Code of Judicial Conduct. So they're making restrictions as to where interviews and press conferences can take place around the courthouse. No interviews or broadcast activities shall take place in the courtroom or adjacent area. Instead, media must conduct interviews outside the courthouse. All trial counsel are directed to comply and inform their clients, staff, and witnesses of the terms of this order. Electronic devices, such as laptops, iPads, cell phones, etc., shall not be permitted in the Allen County or Carroll County Courthouse. Members of the press and public shall not use laptop computers, iPads, tablets, Kindles, cellular telephones, pagers, personal digital assistants, PDAs, cameras, electronic watches, and electronic eyeglasses. Keep your electronic eyeglasses that record off that day and don't wear your Apple Watch. Parking. No reserved parking spaces are available to members of the public or the media. Street side parking is regulated by the City of Delphi. Media organizations are welcome to make contact with the Indiana State Police Public Information Officer, Chief Nate Lamar of the Delphi Police Department, Major Tobe Lesenby, or Deputy Mitchell Catrone of the Carroll County Sheriff's Department to discuss accommodations for media satellite trucks, large press vehicles. Any possible accommodations are subject to any restrictions set out by the Indiana State Police, Delphi Police, and Carroll County Sheriff's Department. Media contact. Pursuant to the Indiana Code of Judicial Conduct, the judge and other members of staff of Allen or Carroll County are unable to respond to requests for comments or interviews at this time. All concerns and questions from media representatives should be directed to the court. Alrighty then. And finally, the very last update, and this was from earlier this morning, and I don't see any updates regarding Delphi stuff at this time. So this was most recently updated. So the we'll start at the bottom. So the notice to court filed 10/1/2024, State of Indiana filed their supplemental witness list and exhibit notice. And then same day, there's I think it's pronounced Praecipe or Precipe, I don't know, Praecipe for transcript. So they requested a transcript, basically. Richard Allen did. Richard Allen also yesterday filed his defendant notice of submission of supplemental witness and exhibit list. So he submitted it to the state and now he's notifying the court that he submitted it to the state, basically, is what that is. So witness lists have been exchanged at this point in time. And October 17th, apparently, we're going forward. Did I say 17th or 14th? Now I don't remember. I'm confusing myself. 17th, right? Because they said the jury selection was the 17th. Oh gosh, now I can't find it. October 17th. October 17th, she will meet with jury selection starts on the 14th, trial starts on the 17th. That's why I was confused. Okay, so 14th, jury selection begins. Trial begins on the 17th, and away we go. And we won't know what happens because she's not allowing any media in, which I don't trust mainstream media. So anything that they report, I'm not going to believe. I'm only going to believe it if there's someone that is an independent something or other that can get some kind of access. But I think it's extremely restrictive. It infuriates me being kind of part of the media that I wouldn't be recognized as a member of the media if I wanted to go in there myself, if I felt like driving to Delphi, which is probably pretty far. I've not looked, but from me in Chicago, it's a ways. So it basically excludes anybody that might be an honest journalist that doesn't work for a mainstream media organization. It excludes anybody that might actually report appropriately on this case. Everyone else is going to be like, oh, Richard Allen's guilty. He did it. Oh my goodness. Because that's what the media want you to believe. That's all I have for you guys right now. Unfortunately, I wish it was better. I mean, I wish the situation was better for Richard Allen and his defense team going in, being able to defend him. I wish I felt stronger about that, but I feel like they have been really handicapped. And I don't know what they're going to do now. So I hope they have some things up their sleeve that we don't know about. Hopefully we hear about it and it gets reported on accurately. All I gotta say. I know there are gonna be some people, you know, YouTube people that are gonna try to get in. So hopefully we'll have somebody do that for us and then we can maybe piggyback on their reporting. So hopefully we get some answers. It just infuriates me that we're not going to be able to see it. I love watching trials. I love, especially in a trial like this, case like this, where there's so many inconsistencies and there's so many things that the state is trying to hide. It's important that we do keep an eye on what's going on. It's important that we pay attention to these things. And I'm surprised that there hasn't been a news media coalition that has come together to try to get cameras in the courtroom and to really, really fight it because this is one of the cases that America needs to watch. I believe this is a case that all of America should be watching because it's going to change the outcome of what a lot of people think about law enforcement and trusting the system, trusting prosecutors and judges. That's why this needs to be public. And I really, really hope I have very little belief that she's ever going to change her mind, but I still am going to hope that Judge Gull changes her mind and lets uh, um, reporters lets us stream this trial, but I don't think it's ever going to happen. Let me know what you guys think in the comments below. I know we went over a lot of different topics. So anything you got to say about anything we talked about today, let me know. And thank you guys so much for watching. Please hit the like button on your way out, and I will see you guys in the next one. Take care.